very good evening to all of you, friends. Very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. Today, we bring to you a very important session on the law of remission in India. Now, why is this particular knowledge important for you from the standpoint of a CLAT aspirant? Now, first and foremost, there was a news that the Supreme Court has struck down the order of remission by the Gujarat government insofar as releasing 11 convicts in a in a criminal case. Today we will understand did the Supreme Court say insofar as the law of remission in India is concerned. So today I am going to discuss with you the importance of law of remission. What do we first understand by law of remission? Because this was there across India in most of the news channels, in most of the print media about remission, a recent judgment of the Supreme Court on law of remission. So guys, let's start with this. Now, before I begin, let me just inform you guys that we are having Jamia Millia open mock between 15th of January and 21st of Jan. It is absolutely free of cost. Go to the description box below and sign up for this. Register yourself. Get to understand the kind of real examination, Jamia, then SLAT between 22nd and 28th, free of cost. All you need to do is to register for this very important mock test. BYJU'S Exam Prep brings to you ACE CLAT with BYJU'S Exam Prep. Unlock your 3-day free trial access to all our courses. Now, what was in the news? The news said that the Supreme Court very recently, January 8th, 2024, very recently, set aside the remission of 11 convicts who were sentenced to life imprisonment for multiple murders, gang rapes, including that of Bilkis Bano during the 2002 communal riots in Gujarat. So, during the 2002 communal riots in Gujarat, there were a number of violence that did take place. Amongst them was this multiple murder and gang rape charges against 11 people. One of them was Bilkis Bano, the victim. So the victim challenged the remission order which was passed by the Gujarat government insofar as releasing. Now, these 11 people were given life imprisonment. Please understand this. So, these 11 people were given life imprisonment because they committed murders, gang rapes and all. Now, the Gujarat government released them on remission. That was on the news. A judgment by future Chief Justice of India, Justice B.V. Nagaratna, right? She is right now a judge of the Supreme Court. She in future will become the first lady or the woman Chief Justice of India. Now, why did the Supreme Court set aside the Gujarat government's order? Now, the incident took place in Gujarat. Thereafter, there was a transfer petition filed, and owing to this transfer petition filed, it was decided by the courts that the trial would take place in Maharashtra. Why? The government was involved, there was a lot of political angle to it, Hindu Muslim angle to it. So the real trial took place not within the state of Gujarat, it took place in the state of Maharashtra. Now, the question is right now, although the incident did take place in Gujarat, because of the orders of courts, High Court, Supreme Court, the trial was shifted from Gujarat to Maharashtra so that there would not be any political pressure on judges, so that there could be a free and fair trial. So, in order to have a free and a fair trial, the trial took place in the state of Maharashtra. It was held by the Supreme Court in this very recent judgment that the Gujarat government was not the appropriate government. Now, the provision relating to remission says that the appropriate government may decide whether to release an individual prior to the punishment or not. So, release of a prisoned person. If you are releasing, the government can release a person who is convicted of certain charges based on he has reformed himself, okay, he is the sole bread earner of the family is starving to death. Now, those kind of other factors are there. We are going to study that. So, the Supreme Court in this very important judgment held that the place in which the trial takes place, that state government is the appropriate government to decide on remission. It is not the state government where the incident has taken place. This was the judgment all about. Let's move and understand the various aspects of this particular judgment. But before that, if you are preparing for other law entrance tests like ALIT, like Jamia, like Symbiosis, Maharashtra CET, there are a host of other important law entrance examinations. If you are planning for those, then you want to talk to our counselors. Go to the description box below. You will find a format, fill it in, and we will speak to you directly. Okay? Now, in this particular judgment, coming back to Justice Nagaratna's judgment, the judgment that was authored by Justice Nagaratna. Now, over here, the Supreme Court says that can heinous crimes against women permit remission? Now, these were certain offenses like gang rape, murder of women, then raping them. Now, it is perceived in our society that woman deserves respect. Now, if you are trying to give remission to those who have committed heinous crimes like gang rape, murder, multiple murder, should the government give them remission or shorten their period of imprisonment and let them be amongst individuals in the society? This is what the judgment clearly says. A woman deserves respect. Howsoever high or low she may otherwise be considered in society, whether she's a rich man or a poor lady, a woman deserves respect in our society. To whatever faith she may follow, Hindu, Christian, Parsi, Muslim, whichever religion they belong to, whichever faith they may follow, or whatever creed they may belong to, higher class, lower class, whichever part of the society they belong to, can heinous crimes against women permit remission? That is the sole issue that was concerned in this particular case. So the sole issue was, number one, who is the appropriate government? And secondly, can these kind of crimes, people who have committed these kind of heinous crimes, like crime, the worst of the worst crime against women, gang rape charges, can these people be allowed to get remission from the government? Now, here is a very controversial topic because this is right now a judgment. As you know, let me give you a recap right now. Incident took place in Gujarat, was shifted out of Gujarat to Maharashtra for a fair, free and a fair trial. And then the Gujarat government gives remission. Which is the appropriate government? Question mark. Can these kind of people who have committed such grave offenses be allowed, be permitted to get this remission? Now, the Supreme Court, in its judgment, had to interpret certain very important procedure. Okay, right? Yeah. So guys, I hope that you guys are all understanding this. Any question, you let me know. Okay, thank you so much. And you guys, if you are liking this session, do press the like button. If you are liking this session, do press the like button, guys. Okay, fantastic. Great to see that. Okay, chalo, आगे बढ़ते. Now, the next important question that came in front of the court was, what is appropriate government as stated under the Code of Criminal Procedure? Now, there is this very important section which says 432 to be precise of the CRPC, which mandates that the appropriate government to seek opinion of the convicting judge for pre-release. So premature release means before the sentence is over. You talk to the judge who has given him conviction and say that, these are those people whom you had yourself convicted. Now we are thinking of releasing them at a little premature stage. What do you agree? Do you agree or do you not? That is what the government generally. So there is a consultation with the judge. Now over here, the Supreme Court very clearly stated that the appropriate government, the term appropriate government as mandated under section 432 of CRPC is the Maharashtra government and not the Gujarat government. So while interpreting a particular section or a provision of the Code of Criminal Procedure, the Supreme Court said that the appropriate government is the government where the trial is conducted. Incident took place in Gujarat, trial conducted in Maharashtra. Appropriate government under the Supreme Court rules, as far as the Supreme Court judgment is concerned, will be the Maharashtra government. Now, what did the judge say? Let's read it. This clearly means that the place of occurrence of the incidents or the place of imprisonment is not relevant consideration. Where did the incident take place? Gujarat. Where are they now? Maybe in Gujarat, maybe in Delhi. Whichever jail is not relevant. And they have been excluded from the definition of section 432 of CRPC. The intent of the legislature is that the appropriate government is of the state in which a convict was tried and sentenced. What is it? What is this? This is Maharashtra. The emphasis is on the place of trial and sentence. The emphasis given under section 432 is on the place of the trial and sentence rather than the place of commission of the offense or sentencing. This also takes within its ambit a situation where a trial is transferred from a competent court within the territorial jurisdiction of one state to another state. So here one trial which was to happen in a particular court in Gujarat was transferred to another state. Here the Supreme Court simply says that the relevant government is that government where the trial has taken place. Maybe the incident might have taken place somewhere else. But the place where the trial has taken place, that is the court. That state government is that government which is referred to as the appropriate government under section 432 of the Code of Criminal Procedure. Am I clear to everyone? Am I clear to each and every one of you? Any question? Any question? Okay. Namra, Shubh. Okay. Okay. So I hope that things are getting clearer, okay? The judgment and the importance of the law of remission. Because, what happens is that based on a very important information or an event or a judgment, they might come up with a particular passage and there might be question on remission. So if you understand what is remission, then it becomes easier if you get something similar. Current OLED, that current legal related to Supreme Court judgment on Adani issue recently asked. Yes, they might ask you. See, any question, any important judgment that comes out from the Supreme Court is important for you. They may relate to the Adani issue that you are asking. They may not relate. They may ask a question on remission, because this is a very recent judgment, and if you are preparing for other law entrance examination, then the examination will be coming up in the month of April, May, June. So that time again, of course, of the year, they may ask you a question on remission. So you have to keep yourself updated. The most important thing is that keep yourself updated. That's all I would say. Okay, let's go back. So what exactly is remission? So from this particular judgment, so we understood the judgment. In a way, we understood this particular judgment. And now let us understand what is remission. इतना बार तो मैंने remission बताया. इसका मतलब क्या है? Now remission simply means reduction or moderation of a sentence imposed on an individual convicted of a crime. So the court says 14 years imprisonment. Remission means to reduce that punishment from 14 years to 10 years, from 14 years to 12 years. After 12 years, based on his, his understanding, he has evolved as a human being, based on various other things, the government can release a person. So it involves reduction in the duration of imprisonment, other penalties. Now, this is done after taking into account various factors and consideration. In a sense, it entails a reduction in the time to be served without altering the fundamental nature of the sentence. So without changing the sentence, you can release an individual. That is what remission means. The state, the government, may grant early release to offenders through remission policies, weighing factors such as good conduct, rehabilitation, time served, and health. So there are various important considerations that are to be looked at when a policy of remission is to be undertaken by the appropriate government on an individual who has committed a crime, by way of which you reduce the sentence that is imposed for the crime that that individual has committed. So here were certain individuals who committed certain ghastly crimes. The matter went on and on in the High Court, then to the Supreme Court, and had attained finality. Here were certain people who were convicted of certain crimes, 11 of them. The appropriate government, that is what the law says, can reduce the sentence without altering the fundamentals of the sentencing. So here the policy that was undertaken, the remission policy, it had to consider whether these people had a good behavior in the jail, had the rehabilitation been done properly, what sentence had they already suffered, are there any health issues, socio-economic issues in the family. Everything has to be considered while the government comes up with all these remission policy. Now again, the Supreme Court over here says, and very important, here these are all kind of passages, okay, that can come up. Okay, please there's nothing question. So I think it's an order of remission does not wipe out the offense. It also does not wipe out the conviction. So the offense and the conviction remains in the text of the judgment. It does not have an effect on the execution of the sentence. Though ordinarily a convicted person would have to serve out the full sentence imposed by the court, he need not do so with respect to that part of the sentence which has been ordered to be remitted. An order of remission thus does not in any way interfere with the order of the court. It attracts only the execution of the sentence passed by the court. So what we understand by remission is the judgment of the court is not altered. The judgment of the court is not even touched. Just the sentencing part, the execution of the sentence has been altered. That is what we understand by remission. I think the process of remission, what remission means, what do we understand, what are the factors that have to be taken into consideration while a remission is done insofar as a person who has been convicted of certain crimes. So the sentencing in the judgment कोई change नहीं होता है. जजमेंट पे अगर 14 साल लिखा है तो 14 साल ही रहेगा, बट उसको 10 साल बाद गवर्नमेंट ने छोड़ दिया अंडर अ रेमिशन पॉलिसी. ठीक है. Liability, sorry, let me just continue from there, and frees the convict person from his liability to undergo the full term of imprisonment inflicted by the courts, even though the order of conviction and sentence passed by the court still stands as it is. The order of the court is not changed. The order of the court is not changed. The order of the court stands as it is. The power to grant remission is an executive power and cannot have the effect with the order of an appellate or revisional court. Would have to reduce the sentence passed by the trial court and substituting its place the reduced sentence. So it is not like, a Supreme Court changing the order of a trial court. No, remission policy is something like order of the court remains as it is. There is no change. एक कोई कॉमा का भी चेंज नहीं होता है ऑर्डर का. Just that the execution of that particular sentencing is being reduced by the appropriate government. Is that clear? Is that clear to everyone? So that is what is remission. Now, two very important things. The precedent. Very important constitutional provision, Article 72. Article 72. Now, when we are talking about remission, certain things you must also remember. Number one is that under Article 72, the president has the power to grant pardons, reprieves, respites, remission of punishment, as well as to suspend, remit, or commute the sentence of any individual convicted of an offense, which may be a court martial, that is army proceedings, or offenses under the laws, that means union government executive power, laws which are under the union government's executive power. So the president is also empowered. The president of India is empowered to grant pardons. Is that clear? To remit, remission of punishment, the president is empowered. So under 72, very important article. Similar power is given under Article 161 insofar as the governor is concerned. So insofar as the governor is concerned, he or she can also provide pardons, reprieves, respite, remission of punishment. He can suspend, remit, commute the sentence of individuals, which are under the laws which comes under the purview of state executive power. So there are criminal laws, state criminal laws, and central criminal laws. For example, Makoka is in Maharashtra, relating to organized crime. So this is some very important facet that you have to also keep this in your mind. Precedent. Now, you have read a judgment of Justice Nagaratna on this particular issue, remission. Now, you might also get a question on Article 161, the power of the governor, or 72, insofar as the president of India is concerned. So keep an open mind. That's all I would say. Now, what are those factors that are taken into consideration? The factors that are taken into consideration while granting remission. Now, whether the offense is an individual act or something that affects the society at large. Now, is the man belonging to Dalit? You want to teach a lesson to the Dalit, the upper caste people, kill lower caste people. Is it a signal? No. You have to keep that in your mind. Is the offense just an individual act of crime? Or is it affecting the society at large? Whether there are any chances of future recurrence of commission of that crime. Whether can these people again commit such a heinous crime? These people who are standing the chance of remission, can they commit this crime again in future? Whether the convicts have lost the potential to commit these kind of crimes. Now, are the convicts right now lost the very old person, in his 60s he might have killed, in his 50s he might have killed, right now he's 90 years old. Whether there are any fruitful purpose of confining the convict anymore. Is there any other purpose rather than keeping this man just in the jail? What are the socio-economic condition of the convict's family? If suppose he is the only bread earner of the family does not have any other person who was working, and he himself committed the crime, he is in jail, the family is shuttered. So these are some of the conditions that are to be taken into consideration while granting a remission under Indian law. I hope that in this session we did understand the law of remission in India. I hope you enjoyed it. Okay. So guys, if you are one of those who are interested in CLAT 2025 UG course, CLAT 2025, get started your preparation with this comprehensive course wherein we are providing you with 380 hours of live classes, 300 plus recorded videos, mock test, practice question, practice test, a study material, doubt resolution, and your CLAT Ignite magazine. One final reminder to all of you. Jamia Millia open mock free of cost 15th of Jan to 21st of Jan. SLAT open mock between 22nd of Jan and 28th of Jan free of cost. Get yourself registered now. Go to the description box below now. Get yourself registered free of cost. Any point in time you want to kickstart your OLED preparation, you want to talk to our counselors, go to the description box below. You have to fill a form and then you can talk to us. We will call you back. For those preparing for CLAT 2025, BYJU'S Exam Prep brings to you Legal and GK Booster Series every Sunday 1 p.m. and 3 p.m. sharp starting the 7th of January 2024. Those of you who are preparing for other law entrance examination tests, we bring to you this test series. Okay, the price has been reduced by leaps and bounds. 15 OLED mock test, all available for you at a very cheap discounted price. Okay, so guys, with this we come to the end. Thank you very, very much. Do subscribe to our channel. Do follow us on our Instagram, like our Facebook page. There's a lot of things that goes on in our Facebook page, in our Instagram. Join our Telegram channel, because we give a lot of information through our Telegram channel to our subscribers, as well as if you haven't downloaded the BYJU'S Exam Prep app now, do it today itself. Thank you very, very much. God bless you. I hope you enjoyed this session. Thank you. All the best. If you like this session, do just click on the like button. Thank you very, very much. Bye-bye. Take care. Good night. Thank you.